Guys, take a good look at this. Key deadlines announced for April and May. April and May have been designated as crucial deadlines in the Ripple versus SEC action. Yes, the trial between Ripple Labs and the U.S. Securities and Exchange Commission is being presided over by Judicial Magistrate Sarah Netburn, who has issued a new scheduling order. The decision concerned Ripple's request that the SEC withhold records and materials meant to be used in a brief pertaining to remedies. In this case, Ripple is at the center of the SEC's brief presentation on the remedies section. Among the matters raised by the parties when they proposed the new scheduling order was Ripple's desire to have the SEC expert documents struck. This showed that the party was serious about finding a solution to the problem. So according to Magistrate Netburn, the SEC must reply to Ripple's motion no later than April 29, 2024. This is in accordance with the directive that was communicated by James K. Phelan on exit. Then, 3 working days after the first date specified in the ruling, on or after May 2, 2024, Ripple will deliver its rebuttal. Reason being, the SEC is expected to react to the remedies arguments put up in this action 4 days before Ripple's answer is scheduled to be sent on January 26th. These files must be accurate at all times. The conclusion reached after consulting the expert materials, most notably, Andre Fox's opinion may prove to be the deciding factor in the claims measurement phase. The scheduling order handed down by Judge Netburn sheds insight on the intricate series of events that transpired in the SEC and Ripple cases, further inflaming the already heated Ripple dispute. Ripple argued that the lack of clarity in the expert report's opening made it difficult for him to offer analytical answers to the issues raised throughout the study. Andre Fox's expert opinion regarding the XRP case is without doubt authoritative, and it is relevant to the massive amount of data included in Ripple's earnings statements and the obligation linked to its digitally sold asset, XRP. There will be less money available because the SEC may lessen the punishment it imposes, even though the court may give serious consideration to the rule-to-rule basis defense. Furthermore, Smith's ability to hold fair and impartial elections is diminished by the publicity campaign that has ensued following Sarah Netburn's nomination to the post of federal judge in the U.S. District Court for the Southern District of New York City. Proceeding from that, we will examine how Netburn's extensive technical understanding of the Ripple litigation and her anticipated selection as a district judge for these and related cryptocurrency matters will influence her decisions in this and future cases. Everyone in the cryptocurrency world is raving about Netburn's strategy regarding the law. There are also many reactions from many different communities to Netburn's selection as a federal judge, including the Bitcoin community. Specifically, Coinbase General Counsel Paul Grohl offered complimentary comment and highlighted Netburn's output throughout the XRP dispute by describing it as a seminar and an industry handbook. The XRP community loved her because of her past criticism of the SEC. That was mainly due to the fact that she had raised serious concerns about the way the Securities and Exchange Commission was implementing the legal principles. For Ripple, Liz has raised a number of important problems, one of the most notable being the rules of the publication of drafts of William Hyman's amazing lecture on cryptocurrencies in 2018. Her dedication to maintaining transparency and equity is demonstrated by this. It is highly probable that Netburn will take a leading role in important cases involving future regulatory clarification and market advancement while serving as a federal judge with the solar gazing. His prior position as senior counsel in the Bitcoin industry is a stark contrast. Just last week, the trial portion of the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission commenced. A large number of companies in the sector, they are hopeful that they will soon be able to put their differences aside and come to agreement. American attorney James K. Phelan recently revealed details of the new scheduling order, and Magistrate Judge Sarah Netburn has entered the order. In particular, the action revolves around the remedy request and the entry of final judgment. Judge Netburn's ruling states that the regulatory body must respond by April 29th, and that Ripple will have 3 business days to reply thereafter. Latest development in the lawsuit follows Netburn's nomination to the Southern District of New York's district judge seat. The XRP army is hopeful that Ripple may soon achieve a major court victory because her previous actions suggest that she has a fairly positive attitude toward the native coin of the company. What sets XR apart from Bitcoin and Ether, as far as I can tell, is not just its monetary value, but also its functionality. According to Jeremy Hogan, the court made a comment in 2021 on blockchain technology and its possible consequences. Hogan recently dropped hints that the lawsuit would be formally settled by summertime in his statement. Individuals who could potentially receive $100 billion in the settlement. In my opinion, the judge will impose a $100 million penalty on Ripple, but he will give the SEC a break by ordering the company to pay no disincentive. So the firm has a history of fine attempts from the Securities and Exchange Commission, which asserted that it had broken many XRP sales restrictions and sought a $2 billion fine. That issue was Ripple's contention that the agency lacked jurisdiction over its native coin since it was not a security. The corporation's chief legal officer, Stuart Aldarity, put forth a number of compelling arguments in favor of a penalty cap of $10 million. Ripple Labs cryptocurrency, XRP, has been in the news recently due to a flurry of activity involving whales exchanging multiple coins worth $180 million. This event has sparked curiosity in the cryptocurrency community, especially regarding the legal procedures involved in the ongoing battle between Ripple and the Securities and Exchange Commission. The timing of these whale trades has sparked worries about the potential ripple effects on the market. Many more people are paying attention to the cryptocurrency industry now that XRP's price has seen some improvement. However, attention soon shifted to the behavior of large holders or whales who executed many major trades involving over 180 million EXA tokens. These actions led to the transfer of 26.67 million XRP from Binance to a wallet that is still unknown, as reported by Whale Alert. Investors' optimism about blockchain cryptocurrencies' potential price increase was boosted by this transfer. Another large transfer, this time involving 100 million XRP in 2 anonymous wallets, has added fuel to the fire of suspicion surrounding the cryptocurrency. David Schwartz, the chief technology officer of Ripple, and Charles Hoskinson, the founder of Cardano, have expressed divergent opinions regarding the contentious ETHgate idea. In what can be defined as a confrontation between 2 crypto heavyweights, the chief technology officer of Ripple and the founder of Cardano were recently at odds with one another over ETHgate, which is one of the most contentious issues in the industry. Over the course of the weekend, discussions concerning the ETHgate idea were brought back up during an episode of X Spaces that featured Hoskinson. It has been stated by Hoskinson that the disputed ETHgate theory is surrounded by 2 different narratives. Over the course of the weekend, discussions concerning the ETHgate idea were brought back up during an episode of X Spaces that featured Hoskinson. It has been stated by Hoskinson that the disputed ETHgate theory is surrounded by 2 different narratives. There is a first narrative that suggests that executives from Ethereum built ties with members of the SEC's internal staff in order to achieve better regulations for Ethereum in comparison to other crypto assets. The second narrative, on the other hand, is comprised of assertions made by a few crypto enthusiasts who assert that Ethereum took advantage of its contacts with the SEC in order to initiate legal actions on Ripple and XRP. Trading advice should not be construed from the data that has been supplied. If you use the information on this page to make an investing decision, you should know that we are not responsible for any losses that may occur as a result. We recommend that you consult an expert in the field and do your own study.